Hello, my name is Marcelo Figueiredo, and I will talk about conventionality control in Latin America, especially in my country, Brazil. We can start saying that the expression conventionality control was born in France, uh, issued by the French Constitutional Court. However, it was the American continent that this type of control reached the greatest development. There is no express test in the American Convention of Human Rights alluding to the control of constitutionality. However, it was the court, the Inter-American Court of Human Rights, and not the European Court, that began to require since 2006, especially in the case Amonacid Arellano versus Chile. That case was judged that the judiciary of the state parties to the American Convention on Human Rights, in this case, exercised control over the conventionality of the domestic legal standards that apply to a specific case. Well, what is the conventionality control? We are going to see slowly when we are talking here. The conventionality controls represents an instrument for standardizing the treatment given to human rights in our region, in Latin America region or Ibero-American region, with a view to establish and solidifying a transnational normative project, a regional community law, or we also say a jus commune for the Americas, which, strictly speaking, is expressly provided for in our case, Article 4 of our Brazilian Constitutional. It is known that international human rights treaties are constitutional in nature and are immediately applicable upon ratification without the need of any subsequent domestic act. Article 27 of Vienna Convention excludes domestic standard as an obstacle to compliance with the American Convention of Human Rights, except in case where, with the conclusion, there has been a violation of a fundamentally important rule of domestic law as per Article 46. Article 2 of the American Convention, in turn, determines the adequacy of national legislation to allow the enjoyment of conventional rights and freedoms. The vertical compatibility of domestic legislation with human rights agreements or treaties is called exactly conventionality control because the parameter of its adequacy is located in an international treaty, in a convention, and the result of the jurisprudential evolution of that court, of the International American Court of Human Rights. The doctrine of conventionality control established by the Inter-American Court of Human Rights required that national judges take into account, when resolving their cases, both the Pact of San Jose of Costa Rica and the interpretation given to it by the same court. Part of the doctrine states that conventionality control occurs at two levels. At the upper level, where we find the controlling material or reference, which enjoys a sort of conventionality supremacy, and at the lower level, the controlled material. The controlled material is the national law. Constitutional laws and other internal regulations. For example, you can see the case Trabajadores Cesados del Congreso versus and another one, Aguado Alfaro and others, among others, versus Peru from 2006. The concept of controlling material also includes human rights, treaties that the state has signed, accept and ratified, starting in our case with the American Convention of Human Rights, also known as the Pacto of San Jose de Costa Rica, as well as the criteria established by the International Court of Human Rights, decided in its advisory opinions and its judgments in their decisions. The controlling material in the event of a conflict may result in the non-application of the rules existing in the controlled material, also known as repressive judicial control of conventionality, the known issuances of regulation by the states, also known as preventive monogetic control, or given rise to the repeal of current regulations that are irreconcilable with the controlling material, restorative monogenic control, and furthermore, through control, constructive or positive conventionality allows for recycling in domestic law. One must always seek compatibility between national standards and those of international human rights law. If this task proves impossible, the local standard must be disapplied, promoting its abolition or modification. One must also remember the doctrine of the application of the standard must favorable to the person, or also known as pro persona doctrine. If the domestic standard is more favorable or originating from the international human rights law, it will prevail. It is clearly provided for the Article 29(2) of the Pact of San Jose of Costa Rica. The doctrine of conventionality control demands precisely compatibility between both legal systems with the aim of achieving greater realization of human rights in the domestic sphere, with international human rights treaties serving as a parameter, which, in the inter-American case, is mainly represented by the American Convention of Human Rights, materializing what is formally provided for in the document. It should be noted that the Inter-American Court of Human Rights is not a court that is above the courts, constitutional courts, or Supreme Courts in the various Latin America countries. Furthermore, there is no hierarchy between them. That is why it does not even constitute an appeals body. However, its decisions oblige the country that is condemned to do or not to do something. It's the pacta sunt servanda. No one is obliged to assume international commitments. Once they are assumed, they must be fulfilled. Finally, we recommend reading some studies the following cases of international Court of Human Rights. The Last Temptation of Christ. It's a very interesting case that occurs in Chile in 2001. As you know, Chile was obliged from this case, since this case, to change his constitution. This case was very important, right? Also, the adversary opinion number 13, Tibi versus Ecuador, Rodila Pacheco versus Mexico, and Gelman versus Uruguay. Also, for those who can speak a little bit of Spanish or Portuguese, I can recommend my book. It's not because it's the best book on this issue, but just because it's a very condensed opinions and doctrine about what is the conventionality control in Latin America, especially in Brazil. It's a short book and it's recommended. One of those books that you can read about conventionality control if you speak Spanish or Portuguese. I presume that if you speak Spanish, you can understand Portuguese. And that's why we speak Portuguese and understand Spanish. Thank you so much for your attention. See you around. Bye bye.